94.4 Spice FM, Nairobi.
Conversation with Her Ladyship Justice Martha Koome, Chief Justice and President of the Supreme Court of Kenya City. You had a question before we took the break.
Several, actually, but let me ask the one which I consider to be most pertinent. What has the Supreme Court done to ensure that the public understand its mandate, its role, and how that affects and influences their lives?
Unfortunately, for judges, we do not communicate the way politicians do at funerals, at religious church services, weddings. We communicate through our judgments, but we are trying to set up a communications department that can continuously, now that we are doing things technologically, that can continuously let Kenyans know what Supreme Court does. And I thank Spice FM, Standard Media, and the KTN, because you have been giving us some airtime. Justice Thursday, which comes, I think, after every 2 weeks. Every week, actually, to explain to Kenyans what it is that the judiciary does. How can you access justice in every court, including the Supreme Court? What can you file before the Supreme Court? So we need more engagement with the public, because we are doing a lot for the public. We have what we call the multi-door approach to justice now. You don't have to come to court to resolve your dispute. We have a court annex mediation, whereby you can discuss your matter, enter into an agreement, and we adopt that agreement as the order of the court. We have the alternative justice system that has incorporated our customary way of resolving disputes. You will recognize that Africa is the depository of knowledge on dispute resolution. Every community and a way of resolving their own disputes, which we discarded for the colonial formal justice system. And our justice needs survey has revealed that it's only a very small percentage of Kenyans who can access the formal justice system in the courts. So we resolve our matters in our communities, before the chief, before our religious groups, in the marketplaces, before our nyumba kumi. And therefore, we must connect as a judiciary with those forums where decisions are being resolved every day and adopt a way of working together with those groups. And that's what we are doing under our program of alternative justice system.
Why I asked the question?
Dispute resolution is very, very important.
Absolutely.
And if this country embraced dispute resolution as a first resort, we would never have gone through all this that we have gone through politically. Because if you look back, you will see that people started with a political dispute, which ended up in the court. The courts have no legal solutions for political disputes, because what we do, we try to make them legal. These political contestations, we try to look for the issues, to look at them through the Constitution or through the Electoral Act. At the apex, people are divided down the line. So whichever decision you make, you will have an equal number that is dissatisfied with that decision. So they end up at the table to negotiate NDR. Then they come up with a solution. Musumkate, handshake, broad-based. If we started there, would we have suffered the kind of bloodshed, the kind of destabilization, property loss, the kind of trauma the country has gone through? So it is important for us Kenyans, first of all, to know we are Africans. We are a system of resolving disputes, which is restorative, which creates harmony, which leads to a handshake, and people thereafter live in harmony. So this is where we are trying to connect with the public to understand that the judiciary is a facilitator and a connector. So when we tell you embrace NDR, it's not because we are unable to resolve the problem. It's because we know the courts determine. We don't resolve.
It's a determination.
Yeah, because from there somebody is aggrieved. Then if you have members of the same family, it's a succession matter. You are coming from the same household. You will be divided. Your children will be divided for generations to come. But if you agreed among yourselves and you greeted each other and you brought that agreement and we adopted it as the court, then we become a facilitator, we become a connector. We build harmony, we build unity, we build peace. That's what we are looking for, to connect with Kenyans.
You actually have connected because of the three arms of government. The judiciary in this country is the most trusted of the three arms of government. And as you correctly put it, it is through the judgments, yes. But I look at the transformative nature of what it is that the judiciary has done to try and ensure that Kenyans find ways of resolving the myriad of issues that they have. We have a front row seat here, so we know. It's talked about every Thursday, but there are very many people who don't know, and because they don't know, they can't benefit from something which actually exists. I personally have participated in some court issues that were online, and I was actually fascinated. Now, these are things that didn't
exist
before. They simply didn't. So everything about it is as useful as it is known. The more people know it, the more they will consume it, and the more they will benefit from it. And the opposite is, of course, true now. My last question to you is, if somebody has a complaint against a judge who is the Supreme Court, where does one take it?
Oh, many places. First of all, if you are aggrieved by the conduct of a judge or a magistrate, we have inbuilt systems and structures of complaints. Judicial Service Commission exists to deal with those complaints. You can file a petition before the Judicial Service Commission if the grievance you have is the one that leads to a removal of a judge. Within the judiciary, we have established a system of dealing with complaints. We call it the Office of the Judiciary Ombudsperson. That office, and it's online, something that we really need to communicate with Kenyans, that the judiciary has gone ahead of the entire government to operate virtually, to have e-filing. So you do not have to walk to the Supreme Court to register your complaints. You can do it online. And we have explained to Kenyans how you can launch your complaint. So it could be a complaint of the judge owes you money. I think that's a civil case. You can also be advised to file a suit, or the judge was disrespectful to you. Is that a matter of misconduct? So that, or whatever complaint it is, it will be handled until resolution. Because of the fair administrative action, the rule of law requires fairness. We cannot mob lynch anybody. If there is a complaint, we must give a chance to the other side to respond. So that is why people think that if they filed a petition against a judge before Judicial Service Commission, they are not seeing results in the next 1 or 2 months, because the complaint will be processed. We will do our own investigations. We will conduct a hearing, and the judge will be given a fair chance to defend themselves, including with a lawyer. Then a decision of the panel will be taken before the whole Judicial Service Commission. We're talking about human rights. We are talking about somebody's livelihood. Then the results will be taken if they are for setting up a tribunal, to the president to set up a tribunal. Since I've been the Chief Justice, I've seen those processes. I think I'm seeing the fourth one now.
Yeah.
Yes.
Chief Justice, I want to look at the interplay between the three arms of government. One does not sit in a position of authority over the other. It is assumed that all three sit independently, but in the same capacity as forming government: the executive, the judiciary, and the legislature. Most recently, we have heard from one arm of government there. I believe it was actually at the conference, at the celebration of 12 years of the Supreme Court, where terms such as judicial interference come up, where terms like, warnings to the judiciary about what they can, cannot, or should not do. Where do you sit? Where is your position there when you hear things like judicial interference that should that in one way or another come against, and I put that in quotes, against the processes that a country would take?
Yes, like you rightly say, Amimo, each of those institutions are independent. And that independence is created by the Constitution. It's none of our creations. And there is every justification for that independence and separation of power. So when the executive or the legislature complains about judicial overreach, we also complain about their overreach. And we defend the independence of the judiciary most vigorously because judges, magistrates, decision makers, adjudicators, we are supposed to decide the cases independently the way we see the evidence and the way we see the law. And if they are aggrieved, there are mechanisms of appeal. If you are aggrieved by a decision of the magistrate, please do not verify them at the church, at the funerals, at open places, because we have no way of responding. Appeal to the High Court, and the High Court will correct that mistake. And if the High Court does not correct that mistake, the Court of Appeal will. And if it's a matter that can come to the Supreme Court, all of us cannot make the same mistake.
Chief Justice, do you really think they make those complaints with a desire to have such decisions re-looked at, or do they not sound like warning signals that come out to the public in terms of what the judiciary ought to or ought not to do?
I think to be a judge or an adjudicator, a judicial officer, you need a very thick skin because you should not be listening to what the public is saying, because you will hear many messages depending on the way they want the case to go. It will be either the executive, it will be either the legislature, but it will also be the public, the way they would want the case to go. So you must always remain very faithful to the oath of office that requires you to be independent, to be impartial, and to decide a matter without any bias or without any prejudice. In fact, that is the oath of office that reverberates and rings the bell to you all the time, so that so long as you're doing the right thing, you're just interpreting the law and the evidence before you, you're making a determination, then you are a functus officio when that matter comes again, because you decided, let them go on appeal. And the people trying to prosecute their matters in public, they know it is wrong. They know that they are circuiting the system. They are bringing to bear undue pressure on the adjudicators who have a matter live before them. So that is why you heard me say sometimes I don't listen to the news, because you know you don't want to be biased. You want to just remain with your own mind.
Truthful to the law, and truthful to, what has been laid out in law. When, again, I go back into the spirit of the Constitution and the spirit of our law. In the spirit of the Constitution, it came out into the letter of the law. And people have talked about our Constitution as being an activist Constitution. Just starting from the very top and says it establishes the sovereignty of the people. And then it comes and looks at how the people then exercise that power. They have the power. They establish these institutions and they say the judiciary shall be the one that makes sure that this constitution lives and continues to breathe. It has established the Bill of Rights, a very progressive one. Article 10 of the Constitution on how we expect that state officers shall behave and how we expect that our relationship with the public shall be. At Chapter 6 of the Constitution, and so on and so forth. And even in areas where decisions that are made shall come from concurrence with the sovereign, and that's the people. So the expectation is that the Supreme Court, that's given that mandate of defending the Constitution, will always be considering, even as you're setting the jurisprudence, it will be in the defense of the Constitution primarily. Am I right? Now then, the public perception at present, for example, if you just look at some of the public sentiment, is there's a feeling that the judiciary, the Supreme Court is dropping that ball. That the Supreme Court is looking at matters in terms of what has been presented before it, but forgetting that there is the spirit of the Constitution of Kenya.
The Supreme Court, Eric, has not dropped the ball. The Supreme Court has breathed life and spirit to the Constitution, and we continue to nurture our Constitution and to celebrate it and to uphold it. For instance, the recent case from the Supreme Court on the Finance Act. Unfortunately, many people have not read that decision. They have not even read the media summary. When I saw the debate that was taking place, immediately we rendered that decision. First of all, the discussion was the Supreme Court has disagreed with the Court of Appeal and the High Court. That is wrong. We did not disagree with the High Court. We were in tandem with the High Court. The only dichotomy was with the Court of Appeal when they declared the entire Finance Act unconstitutional, from the title to the descriptions to everything, to the schedule, to everything. We hand up, and for the reason that there was no public participation after the second reading of the bill. You remember, Eric, that the Court of Appeal had already established the parameters of public participation in a case which we call Pivans. The Supreme Court had also determined the parameters of public participation, mainly in the BAT case and also the BBI case. Now, when you come the second round and say after that public participation, which was found to be satisfactory, because even the Court of Appeal agreed the first round of public participation was satisfactory, then you move the goalposts and say after the second reading, you must go back to the public. The Finance Act or bill has timelines. It must be completed within 60 days. And we analyze that process, the judgments, and so actually the amendments which were introduced, the 17 or 18 of them, were issues that arose from public participation. And we were able to say, this is what this group said, this is what is contained in this clause. This clause is from this body, this clause is views from this body. So we said that this is the views that came from the people and were incorporated in the third reading. In the second reading. In the second reading. Therefore, it was not satisfactory for the Court of Appeal to say they needed to go back to the public participation when the views that were actually added were the views that came from the public participation. However, the Supreme Court went on to emphasize that if there are new issues that are being introduced in the second reading that did not emanate from public participation, then it is necessary for Parliament to formulate framework of engaging the public even after the second reading. Even if there is a short window, they must have a way of telling the public that these are the new issues that have arisen from the floor, not from public participation, but, from other sources. So we have breathed life and spirit to the Constitution.
Were you satisfied that Parliament did that? In the case of Finance Act 2023?
Satisfied.
That there was nothing that was introduced after the second reading that had not been canvassed during public participation.
We did that, and I invite you, Eric, to read our judgment. Actually, of all the judgments we have rendered in the Supreme Court, this is the judgment that I find very, very sound.
What then would you say to those who feel that you lowered the bar on public participation?
We didn't lower. We even told Parliament and gave guidelines, very detailed guidelines on what constitutes meaningful public participation, and directed them for the 10th time to enact a law that guides the country on public participation, because even them, they don't want to be experiencing this shock all the time. They need a framework. They need to be guided. They need, to settle this issue of public participation. It's almost 14 years, and it's really been a bothersome topic. But we did not lower the bar. We actually increased the bar by saying if you introduce something new, it must go for public participation. And we evaluated what was there, and so it is issues. The 18 issues were raised by the various parties who made submissions, either by written memorandums or by appearing before the committee.
Your Ladyship, you must also address this one. This is at the point of delivering the decision of the Supreme Court on the presidential election petition in 2022. There are those that felt that the court came out with language that was not what is expected of the Supreme Court. Words like hot air, wild goose chase are still painful to many people.
Well, if somebody feels hurt because of the language that you have used, it's always an act of humility to apologize and say we would apologize to those who felt hurt. But if you read each of the paragraph, it would explain why that was the conclusion. Because if there were allegations that were not supported at all by any evidence, then the conclusion is that which, if it is hurtful, we apologize. But, that is the conclusion we came to after evaluating what was brought to us in a very, very big way. But it turns out that it wasn't what was being arranged.
What should a court like this do? And final question, we've been given time for the news. It's just asking the final. What would the court? What do you like to see when parties come to court with such kind of matters? For example, they allege, but they do not have substantive evidence, and yet you've taken the court's time, the country's time. Instead of using the word hot air, it's okay. We've taken the apology. But what then would you like to see from parties that do such kind of things?
That's why we have opened what we call the multi-door approach to court. And I think the Bible is very instructive. Before you take your brother to court, reason together. So look at this case which you are bringing to court and see whether it has a leg to stand on or even a hand to hold on to. If it doesn't have, approach your brother and negotiate, mediate, and look for another alternative. Don't come to court because you end up more hurt. You end up with a decision that maybe makes you even pay costs. Yes.
Madam Chief Justice, thank you very much for joining us today.
Thank you for having me.
We look forward to the next one.
Thank you.
Asante sana, and say hello to all our friends, judges.
And thank you so much for the support you have always given the judiciary. to inform the public what the judiciary does for Kenyans.
Thank you. The Honorable Chief Justice Martha Koome, Chief Justice of the Republic and President of the Supreme Court, has been our guest. It's 5 minutes after 9.
When I have